And as everybody can well imagine, a lot of things have changed. So we were due for an update. How I'd like to start is I'll introduce myself. My name is Todd Storms. I'm a partner at Templeman. I work in the commercial and construction areas of law. Brought with me today Christy, Mark, and Zach, and they'll introduce themselves when they do their presentation. And give you a sense of what they're going to do. What we're going to do is just, I'll throw it to the associates and they'll give a brief update on what they've been seeing as things change in their specific areas of law. When we were first here, everything was shutting down and we were discussing what to do. Now what we're seeing is certain sectors of the economy are picking up. Mine, for example, construction law is really coming back in force because there's been certain exemptions carved off. Certain other areas that I've been consulting with, i.e. restaurants, are starting to ramp up in a different way because they're allowed to do curbside pickups and things like that. Logistics and transportation companies are running full bore, but as other companies get online, they have been needing consultation, and we've been doing all kinds of that. And I thought it was a good time to come back. So what I'm going to do is plug a few things just before we get started, and I'll put them in the chat as we're talking. One is I'm going to update I encourage everybody to go to our Twitter feed, and I'll give everybody our Twitter account while we're going through. The reason I'm doing that is because different groups in our firm are putting up very frequent updates with respect to what's going on in law and their areas of practice. So labor and employment constantly, it feels like every going on in those jurisdictions. I highly recommend that you get onto our Twitter feed, which I'll give you the address for as the associates are talking. We also have an email list that we've been doing in those groups, and I don't like to just dump names onto that. So if you're on this call, I won't be bothering you with an email. But if you want to get on those email lists with respect to especially commercial related matters and construction related matters and employment related matters, I'd ask that I'll send out my email and I'll send out Christy's email. If you contact us directly, and we will put you on those lists and give you updates. And lastly, I'm just going to do I put this on the Twitter feed too, but Mayor Panchuk of Belleville up on the City of Belleville's YouTube page did a really good update on the status of COVID-19 and sort of the starting up of businesses and what he's been seeing. He did put it up yesterday afternoon, and it's a good update, and I've put it on our Twitter. So if you want to see sort of the state of Belleville as it sat yesterday afternoon, please check it out as well. So as Jill said, we'll do questions at the end, and we've got some questions beforehand, and I've asked the associates to keep those in mind and address them as we go, and then we'll be happy to take questions. And as I understand it from Jill, at the end of it all, we'll open it up to some discussion and happy to talk to everybody about any questions that they have for us. So without further ado, I will turn it over at this time to Zach.
Hey, my name is Zach Fleming Giannotti. I'm an associate here in our construction and commercial litigation group. So dealing primarily with clients, businesses, small and medium-sized businesses, when they need to litigate or when they're pre-litigation. So in other words, when there's a dispute that they have on their hands. So today I'm going to be brief. I'm just going to give you a brief update on what is happening in our neck of the woods in terms of litigation. So right now, there's somewhat mixed messages between within the profession and what's being communicated to the public in terms of the status of the courts. Essentially, the way that everyone is operating, though, I can tell you is that for virtually all intents and purposes, the courts are closed at least until July 6th, 2020 is the current status. There are exceptions. They are limited, though, to matters that are urgent. Typically, this is being reserved for life and liberty issues as opposed to financial or commercial disputes. So the type that many of you may find yourselves in. That said, there are exceptions being made, and we've been a part of at least one of those that where courts have agreed to hear issues on an urgent basis. So it isn't impossible, although it is rare at this point. At the moment as well, limitation periods, so essentially timelines or court-imposed deadlines for either commencing proceedings or taking certain steps in proceedings are postponed, with the exception being in relation to Construction Act proceedings, so if there's a lien claim or something like that. And the result of that, again, is that things are generally being elongated because of the time periods being postponed. So, quickly, what does that mean for you and for our clients? In a nutshell, although litigating is slow at the moment, and it's definitely different than it was, before this all happened, there are still ways to progress through the courts. We're still issuing actions on behalf of clients. We're still advocating on behalf of clients. We're still writing demand letters. And ultimately, we're still resolving disputes for clients. So what that means for you and for your business is if there's something that you have that's ongoing in terms of a prospective dispute, be it an unpaid invoice or some other deal that you had expected to get done that isn't now as a result of COVID, and you feel you're in a position where litigation may be your only option, or where you think that you're heading that way, we can still commence actions for you, and we can still resolve things for you. And so we're encouraging clients to at least take the initial steps, even though there may be a longer delay in the court system right now. We're encouraging clients to take initial steps and hopefully getting somewhere in the interim. And when things open up, we'll be that much better positioned to move forward. So that's all I've got today in terms of an update on the litigation front. I'm not sure if Todd is going to be kind of stepping back in here. I think you're muted, Todd.
There we go. Sorry, Jill had me muted. So we'll go over to, which is probably a good thing. We'll go over to Mark now. I don't want to make Mark and Christy nervous, but I just noticed that my wife joined, so be impressive. Yeah, we need Mark. We need Mark now. Mark Noble. There we go.
So I have to re-say all of those impressive things I just said? Okay, I'll try to remember. My name is Mark. I am going to talk about commercial leasing and the impact that COVID-19 has had in the commercial leasing sector, whether you're a tenant or you're a landlord. The question we're getting from a lot of landlords and tenants is rent has not been paid, or I can't pay rent. What are my options? Does the tenant have to pay rent? Do I have to pay my rent? If I'm the landlord, what can I do if my tenant has stopped paying rent? Pre-COVID-19, this was pretty simple. The tenant stops paying rent, the tenant is in default. Most leases, commercial leases, will say, "Thou shalt pay thy rent no matter what." And so the landlord would send out notices or follow what's in the lease and take usual collection and enforcement proceedings, which oftentimes resulted in the tenant being locked out and possibly a lawsuit for damages and going and finding a new tenant to take over that space. During COVID-19, we're seeing a lot more motivation to make deals between landlords and tenants, partly because of necessity. It's all well and good for a landlord to enforce a valid provision in a lease that says you can lock the tenant out if the tenant stops paying rent, but the day after, what are you going to do? Or is there another tenant waiting in line to take that space? Have you just spent a lot of money on enforcement proceedings only to wind up with a vacant building? And those are considerations that landlords are having now more than ever. So the same rules still apply. COVID-19 didn't change the idea that a tenant needs to pay their rent under most leases. The one thing we're seeing is a lot more attention being paid to these force majeure clauses, or these act of God clauses that are in leases. And there's no blanket answer to this question. You have to look at what's written down in each lease. Go to that force majeure clause, which is typically at the back somewhere, and see what exactly it says. Number one, these clauses will generally list certain events that are beyond the control of the parties. Government regulations that affect a business is one that we see commonly in there. Pandemics are sometimes listed. And if it says that, okay, that's good. So the force majeure clause applies. But then you've got to keep going. And a lot of times what you'll see is the force majeure clause will apply to excuse performance under the lease, except when it comes to the paying of rent. That's a very frequent clause that you see in the lease, or a carve out from that force majeure clause. So while we have a pandemic, the lease says that performance is excused on the part of a tenant during the pandemic, but that excusing of performance doesn't apply to paying rent, so pay me my rent. And you get back into this scenario where the landlord and the tenant are now more than ever being forced to negotiate. So when you're dealing with these situations, I think the first step is to assess. Has the payment stopped? Is the tenant unable, unwilling to pay? Has the tenant been shut down? What's going on here? Are we dealing with a big tenant that's part of a larger group of companies that should have the money to pay? Or is this really a small business? Is this a tenant that has been, stalwart for years and years, and this is just a blip on the road? Or is this somebody who's really been a pain in your backside for a long time? That's going to affect how you approach it. And decide what do you need as the landlord? What are you willing to offer as the landlord? How much flexibility do you have as the landlord? I mean, landlords aren't always these, wealthy real estate moguls who can just say, defer the rent down the road and we won't worry about it. What are the expenses at the property? Do you have the ability to defray some of those or push them down? Talk to each other about it. Start a dialogue. If you're a tenant and you're under the gun and you can't pay the rent, have that discussion with the landlord now. Don't let it go. See what options are out there. And if you are able to reach a deal, write it down. What's been agreed to? Who's giving what? When does it start? When does it end? That sort of thing. What we're seeing in terms of options out there and what landlords and tenants are agreeing to is sometimes deferrals, where it's, I've got 4 years left on my lease. I won't pay rent for April, May, and June, but we'll make it up over the balance of the term, sometimes with interest, sometimes without interest. A full-on rent abatement. The landlord says, look, I understand your business has been shut down. This is a long-term tenant. You've been good. We're willing to let the rent payments go because we don't want you to go out of business. So, don't pay for April, May, or June. Or something in the middle, some kind of hybrid of a deferral and an abatement. Look, I'm okay if you don't pay the minimum rent, my profit rent during that, a month or 2 or 3, but you've got to make the basic rent, the additional rent payments, so that I'm not going into the red on my end as the landlord. And then on top of that, we've got a lot of uncertainty with this Ontario Canada Commercial Rent Assistance Program. And the uncertainty is that we know the program is out there, we just don't know the details of it specifically, and there's a lot of questions out there. For example, one of the biggest misconceptions, I think, is the idea that the landlord must have a mortgage in order to qualify. Or if you're a larger institutional client, you're a municipality, a school, you know, a hospital, that it doesn't apply to you. Well, I've not seen anything that says definitively that's the case, and all indications that we have right now is that this program is meant to be flexible and apply in different scenarios, but always with the caveat, and we'll provide you details by the middle of the month. And we're getting on there, we're just waiting for them. The idea of this program is that the federal government and the provincial government are going to combine to offer a forgivable loan for 50% of the gross rent. And we believe that this means the total amount payable by the tenant under the lease, basic rent, additional rent. It's another unanswered question, but it's something that this is what we think it means. Gross means all, so okay. Now, the idea is then the landlord has to agree to abate the rent, forgive the rent for 3 months for 75% of that rent. So whereas you were supposed to pay me $100 in that month, now you only have to pay me $25. The landlord is going to get $50 from the government, and then the tenant is responsible to pay the other $25. Or the government is saying you can be flexible with those arrangements. If you've got a situation where a tenant is, on death's door financially and just can't afford to pay anything, well, there's nothing stopping a landlord for, agreeing to have an abatement of all of the tenant's portion, or deferring that rent for a period of time. There are certain ineligible tenants for this program, which I probably don't apply to most people. These are, the government's made a carve out for groups that promote hate and violence. So, if you're renting to somebody who does that sort of thing, shame on you in the first place, but you're not getting money from the government here. Or if it's a political office, that's not, the government doesn't want to be seen to be, lining its own pockets like that. So we're patiently awaiting these details, but the idea is, for now, those options are out there. This rent assistance program will come online at some point. It will offer some relief and make a deal in light of that. It's not as simple anymore as like, let's just lock the tenant out. For instance, I can see tenants getting crafty and saying, look, landlord, you have an obligation to perform this contract in good faith with me. You didn't even bother applying for this thing. You weren't trying to help me. So yeah, I might have breached my duty to pay you rent, but you breached your duty here. So we're gonna have a fight about that. Or the contract has been frustrated. I don't have to pay because the whole basis of the contract has been frustrated. And the challenging thing for a landlord facing those kind of arguments is you can't come to me and say, Mark, how is a court going to decide this? What should I, because we don't know. There are no good precedents for how the court handles commercial rent disputes in the 20th century in light of a pandemic. So there's more motivation now than ever to make deals, to work together and to find a solution that works. And that's what I have to say about commercial renting or commercial leasing.
Great, thanks, Mark. Okay, and then last we'll go to Christy just before she starts. I'll just remind everybody that, and Jill's put up in the chat room, that if you have any questions, you can put them up on the chat. And then what we'll do at the end of Christy's presentation is Jill can take the mics off of the lawyers, Christy, Mark, Zach, and I, and she can, if you've got questions and you want to address them and talk to us, then she can control your mics going forward and ask your questions. So let's go now to Christy. Thanks.
Thanks, Todd. As Todd mentioned, my name's Christy Nurse. I work with the Labor and Employment Group at Templeman, primarily out of our Belleville office. Also, as Todd mentioned, this has been a really active area of law in the past couple months since the pandemic was declared. So I will try to be relatively succinct to allow time for individual questions at the end. But
Sorry, I think we might have
Lost Christy?
lost Christy. Yeah, sorry. Just give me a second and I'll see if I can't prompt her on her side. Just
Okay.
and we'll see if we can get her back.
I will just pose this question. It's sitting here in the and it's sitting here in the chat, and Mark has answered, so I'm going to direct it to you maybe, Mark. The program applying to charities and nonprofits, but if the landlord is the charity, does casting itself as a commercial landowner for the purpose of the program put their charitable status in jeopardy? I'm trying to unmute you there, Mark.
Gotcha. Okay. And I should start the video again. Okay. Lisa, we've not seen anything that would indicate that a charity would not qualify simply because they're the landlord, simply because they are a charity. I think a charity that's a landlord that's making money to recover its costs, and that this is a legitimate part of its charitable operations. We've not seen no reason why that charity wouldn't qualify for this program. It's another one of these unanswered questions, but I suppose if applying for the program were to uncover a whole scheme of hiding profits like that, well, yeah, I could see that would be a problem, but I think for now we're going on the assumptions that it would apply to a charity.
Mark, going back to sorry, and just to update everybody, Christy's trying to get back on, but and so Jill, I don't know if she might fall back into your waiting room at some point, but in any event, Mark,
I opened up the waiting room.
Okay, can you go back and talk about like, I understood all your options with respect to the landlords and kind of what we're seeing right now, but if you're in a unique situation right now where you're a landlord and your tenant isn't paying and you want them gone, irrespective of COVID, what are your options?
Well, I think your options are the same as they were before, that you go and you move to enforce under the terms of the lease. And if the lease gives you the ability to shut the door, to lock the tenant out, then you can take that option. If the same notice provisions in the lease would apply, you need to go and review those specific terms. What qualifies as a default? Is it as soon as the tenant has stopped paying rent? Does the tenant have to have not been paying rent for a certain number of days? Are there notices that need to go out? Make sure that those are all done, and then proceed under the lease. I think that what is an added wrinkle here is this idea, if a crafty lawyer acting on behalf of a tenant could raise some of these other issues related to COVID-19. But I think if you're a landlord, that your best advice in that situation is, if you want the tenant gone, proceed under the lease and dot all your T's, cross all your I's. And did I say that right? No, you don't dot T's, do you? You dot I's and cross T's, and make sure that the lease has been followed and enforced.
Mark, I have unmuted Lisa, so I don't know. Lisa, do you have any more questions to the answer Mark gave you?
No, thank you.
I'm sorry, I can't do any better than that right now, Lisa. It's one of these, I've seen various groups post, lists of questions. We've got lists of questions, and that's one of them. But it's on the face of what we're seeing, on the Canada Mortgage Housing Corporation website, from the PMO's office, and from the Ontario government. Like there's nothing that jumps off and says, landlord that is a charity, don't bother applying for this. I would think just the principle of it is, of course we want a charity to be able to apply for this and survive, the same way that with the wage subsidies.
Yeah, there's a little bit more complexity to our situation, so maybe we can take this offline when we're done.
Yep, happy to do that.
Thanks.
Thanks, Lisa.
Okay, and it looks like we've got I hope we got Christy back. I can see her anyway. So
Yes.
let's
Everyone
try.
hear me?
Okay, great. Let's try and get.
Sorry about that.
That's all right. So we'll turn it back over to Christy then. Thanks.
Good thing I'm not doing a presentation on IT capabilities. Okay, so in the last webinar, and I assume there may be some new people and there may be some overlaps. So we covered some earlier announcements relating to subsidies and benefits and a broad range of employment issues, including layoffs, occupational health and safety, and some sort of early return to work considerations. The last point is what I'd like to focus on today, but I will touch briefly on some of those other points as well for the benefit of the people that weren't on the webinar last time. All of these issues, as I said, remain relevant and they remain frequently changing. So if you aren't on our email list or you're not following our updates on Twitter, I'd encourage you to use those resources as we're really trying to stay on top of things. As well, Jill did send us some questions ahead of time. So if you did forward a question to her, I will address those in the course of my presentation. And then if there are any additional questions or anyone feels like I didn't answer the intent of the one that they sent, we can visit those then. So I want to start with some updates on government benefits and subsidies that are specific to employment. The one most relevant to employers and small businesses is, of course, the Canada Emergency Wage Subsidy, or the CEWS. As most of you know, eligible employers have been able to apply for this program through the CRA website for a few weeks now. And in fact, the latest eligibility period, as it applies retroactively, opens today. So as of today, you can apply for the wage subsidy for the period April 12th to May 9th. The details of this program are available through the CRA website, and they're pretty comprehensive. So I won't wade too far into the particulars of the program. But again, in really broad terms, this is the subsidy that's meant to keep employees on employer payroll rather than accessing the CERB benefit. And it does that by covering 75% of wages up to $847 per employee per week. In order to apply, you have to show that your business revenues have declined in the eligible periods by 15% in March or by 30% in April and May. And how you demonstrate that is in reference to either the same period last year, so for instance, March 2020 as compared to March 2019, or compared to an average of business revenues in January and February of this year. We also just learned late last week via one of the Prime Minister's daily press updates that there's an intention to extend this program beyond June 6th, which was the end date that was originally announced. We don't know how long that extension will be for, whether it's just an extra month into July or if it may extend into the fall. But again, we're following that and we expect to have some updates on that shortly. Apart from the subsidy, the other major topic for employers who have either had to lay off employees or who perhaps have employees accessing unpaid leaves is the CERB. This is the program that provides $2,000 a month to individuals over the age of 15 who have earned $5,000 in the previous year. Most employees who are eligible for this program are probably aware of it and have already applied at this point in time. But it does look like the government is still evaluating it and making some modifications as we go along. So the last webinar that we did with this group, I think it had just been announced that the government waived the requirement that applicants have zero income and they were going to be allowed to earn up to $1,000. But that announcement was still pretty new and there wasn't a lot of detail about what that would look like or how the CERB would interact with the queues once you start recalling people. So the government has finally updated its Q&A page on the CERB, and I'm just going to share the link with everybody in the chat function if you're interested in finding out more. But a few points to highlight. Most significantly, the government has clarified that employers can't top up the CERB, even if they have other top-up programs in place. So if you have a supplemental unemployment benefits plan registered with Service Canada already, that can't be used to top up the CERB. However, you can still go ahead with registering those plans and then they will apply after the CERB period expires, when employees who have exhausted CERB benefits might transition to regular EI. Next, the government's also confirmed that severance payments won't impact an employee's CERB eligibility. So if there's a deemed termination or another termination during that time, that won't count towards the $1,000. And finally, on the issue of eligibility, if you recall an employee to work and they start earning some income, basically eligibility to stay on the CERB is going to depend on the eligibility period they get recalled in. So if an employee gets recalled during the first CERB period that he or she applies for, they have to pay back all of the CERB if they earn $1,000 in any consecutive 2-week period during that first eligibility period. If they get recalled in a subsequent period, it's earnings of $1,000 over the entire period would trigger the repayment obligation. Word of caution, if employees are approaching you with questions about CERB eligibility and you're recalling people and they're asking how that's going to affect their CERB, we would advise people not to be giving advice to employees that might have financial or tax consequences for them. Really, employees should be directed to either contact CRA for more information or to get their own financial or legal advice on those kind of issues. The next thing, and this is more of moving to a substantive legal document that I want to talk about, is recalls. With CEWS applications having been open for some time now, many employers either have recalled or in the process of considering recalls of employees. How these will function is going to depend on how your layoffs were implemented in the first place and also how long your employees have been off work. So on that issue, one of the questions that we received from Jill on behalf of this group was, when would a furlough or layoff be defined as constructive dismissal? When would the magic date be where this might be inferred? Is there any expectation that the courts will be sympathetic to these claims? So in broad strokes, if you've laid off employees and you did not have a pre-existing employment agreement with that employee that specifically contemplated layoffs or authorized you to do this, you might already be in constructive dismissal territory. The traditional view in Ontario is that even though the Employment Standards Act contemplates temporary layoffs, the employer doesn't have a right to unilaterally put someone on a temporary layoff unless there's a prior agreement allowing them to do so. We are obviously operating in extraordinary circumstances, and at this time, while we imagine that courts might give employers the benefit of the doubt, there might be some flexibility so long as recalls are made within a reasonable time. That's really pure speculation, and similar to what Mark said, this is not an area for which legal precedent exists. So it's really hard for anyone to say with any real authority how the courts are going to approach these issues. And certainly there's been no preemptive statements from the courts, letting us know how they envision these types of cases will be approached. And it'll probably be some time before the first test cases start coming in. So assuming you did have a contractual right to lay off your employees, or your employees agreed to the layoff and there was no sort of issues out of the gate, then the ESA provides that employees have to be recalled within 13 weeks. So a temporary layoff, part of the question was, when does that magic deeming happen? A temporary layoff becomes a deemed termination if it exceeds 13 weeks in any 20-week period, or 32 weeks in a 52-week period if you satisfy certain criteria that are in the Act. So for instance, you've continued to make benefits available or make some other substantial payment to the employee. Of note, British Columbia did just pass some legislation that extended that 13-week threshold out to 16 weeks. We haven't seen anything as of yet in Ontario to make a similar move, but that's obviously something that we're following closely and wouldn't be surprised to see, but nothing confirmed as of yet. In terms of the mechanics of your recall, the process to be followed here might be dictated by whether you're a unionized workplace or not. So if you have a union, your collective agreement probably spells out how layoffs are to be administered. Usually recalls happen on the basis of the seniority of the employees. If you're not a unionized workplace, as with everything in employment law, it's really context specific how this is going to operate, but there are some general best practices. So for example, recalls should be done in writing. They should set out a specific date and time that you expect the employee to report to work. And ideally, recalls would be set a few days in the future, so you're giving your employees a reasonable notice. There's also an expectation that employees will be recalled to the same position that they left. And if that position no longer exists because of this economic downturn or any of the fallout from it, you would have the onus of proving that, and then you're obliged to return the employee to basically the closest comparable position if one exists. Where a recall has been properly and fairly made, so you've given the proper notice, it's a reasonable amount of time, there's no grounds for an employee to stay off work on the basis that they prefer to collect the CERB. So that's a question that we are getting, and I guess it's something that employers have been approached with. There are some caveats to that, and I will get into that a little bit, but they generally relate to either protected leaves or human rights considerations. So this ties into another question that we got from Jill, and that was, under what conditions can an employee refuse to work? So if we're talking about a formal work refusal under the Occupational Health and Safety Act, so that's a refusal that's based on health and safety concerns specifically, an employee who's not in an excluded class, so there are excluded classes of employees such as police officers, nurses, people that aren't really allowed to engage in work refusals. If your employees don't fall into that class, they can refuse work where they have reason to believe that either they, or in some cases another worker, is likely to be endangered by any of the following. So any equipment, machine, device, or thing that the employee is asked to use or operate, the physical condition of the workplace or part of the workplace in which the employee works, workplace violence, or if they're being asked to use any equipment, machine, or device in a way that contravenes the act. So in the case of COVID-19, complaints would likely be grounded in the second point, which is the condition of the workplace. So you're probably going to have employees saying they don't believe that the condition of the workplace is safe or healthy for them. If this happens to you, all of the regular obligations and procedures under the Act continue to apply during this period. And you can be subject to the same orders by the ministry. If you have an employee that's recalled to work, they make an official work refusal citing unsafe work conditions, you follow the procedure set out in the Occupational Health and Safety Act, which in sort of basic terms means you receive the complaint, you investigate the complaint, take any remedial steps. If those don't satisfy the employee, then at that point you engage a ministry inspector who will come in and make a finding about whether the work refusal is justified or not. Apart from health and safety specific work refusals, you might also find that employees are refusing to return to work based on more broad concerns about exposure or just a preference to remain home during this time. We've heard that a lot of employers are struggling with attendance management issues, even those that didn't have to close and aren't making recalls and whose employees have continued to work throughout. And part of the reason for this is employers are really unclear about what information they can ask for during this time. So generally, an employer can't seek a medical certificate to confirm that an employee is actually ill or suffering from symptoms of COVID-19, but any employee who's taking the new infectious disease emergency leave, and that's one of the protected leaves under the Employment Standards Act, the employer can ask for evidence reasonable in the circumstances. So what's reasonable in the circumstances, of course, depends on the reason for the absence, but in many cases, employees without special needs will be expected to abide by your normal attendance policies unless they've engaged in a valid work refusal. Now, the big caveat to that I mentioned earlier, employees might be entitled to remain off work if they claim a protected leave under the Employment Standards Act, or if they have special medical sensitivities or circumstances where forcing their recall could amount to a human rights violation. Job protected leave is in place to cover things like childcare arising while the state of emergency remains in effect. And we know that that has just been extended to June 2nd. So just be aware that anyone who has claimed a protected leave, they're basically sheltered now if it's a valid leave until June 2nd. And because the particular health considerations, sensitivities that I just mentioned can raise human rights concerns, you really need to evaluate work refusals on a case-by-case basis. So it is good to have a general return to work sort of protocol and policy in place, but in the event that anyone refuses, you're going to have to look at each case on its own merits. That ties into another question that Jill sent us, which is what policies need to be in place to bring people back to work? So the answer to this is going to be very, very contextual and specific to your workplace. A retail shop and a construction site aren't going to need the same policies and procedures, for example. But at a minimum, everyone should be thinking about adopting or updating existing workplace health and safety policies. And to help you with this, the Ontario government has published now over 80 sector-specific guidance documents. These give you a good a good overview rather of the expectations around health and safety. They don't go by size of business, but they are parsed out by sector. So I'm just going to post the link to that in the chat function. That is where you can sort of jump off and do a whole host of sector-specific guidelines. You can either incorporate these into your own policies or procedures, or have them as sort of standalone guidance in your workplace. But I would say it's really important not just to, review them, adopt them, and file them away, but to educate your workers on what you're doing and what your expectations are. The gold standard is to have policies acknowledged by your employees in writing. So an acknowledgement saying they received the copy and they got some training on it. But at a bare minimum, they should be communicated to employees if you expect them to be followed. Now, if you go through some of the guidance documents at that link I just posted, you'll see there's directions for certain sectors on what to do if there's a positive COVID-19 case in your workplace or there's suspected exposure. So for instance, there's a detailed procedure for construction sites. Again, and we discussed this in the last webinar, employers have to balance their obligation to have a healthy and safe workplace with their obligation to safeguard the medical information of employees. So if there's a report of a positive or a possible exposure, you'll need to balance what information you need to tell your general workforce so that they can protect themselves against the fact that that potentially is the sensitive medical information of whomever tested positive. If you don't have a procedure on how employees report illness, a sickness or accommodation policy, for instance, that's perhaps something that you should consider during that time, this time rather, and you should probably seek legal advice about what that looks like, because again, that's going to be specific to your workplace. Finally, we expect to see an uptick in harassment and discrimination complaints during this time as employees take issue with employers, asking them to return to the workplace or prompting them to do work that they simply don't want to do. Under the Occupational Health and Safety Act, employers are required to have a workplace harassment policy and procedure in place. And these policies should include procedures for dealing with complaints. So they should guide you through receiving, investigating the complaint, and how it will be dealt with. If that's news to you, probably a good time to think about implementing a workplace harassment policy. Finally, the last question that we received ahead of time was, what does compliance with safety precautions look like in a small office, large office, store, etc.? So I would refer you back to the link with the guidance documents. Again, those aren't arranged by the size of employer, but they are sector specific. Compliance is obviously going to depend with the type of work that you're doing, but the guidelines set out general frameworks for workplace measures physical barriers, basically what we think ministry inspectors would be looking to see in your workplace. As a final note, because we've had this question in other presentations, to the extent that you as an employer are concerned about your liability if a returned employee becomes ill, if you're an employer who either is required to have WSIB coverage or you've opted into providing coverage, and that will cover a number of different sectors. The WSIB has confirmed that it considers COVID-19 a compensable occupational disease where applicable criteria are satisfied. So what this means is that in general, an employee will have a right to claim WSIB benefits if they become sick as a result of returning to work, and that will be in lieu of a direct action against the employer. Now, that being said, we obviously still encourage employers to take all steps that they can to minimize the risk of anybody becoming ill, whether that's your employees or as you begin to welcome customers back into your workplaces. And following public health and safety recommendations, implementing those guidelines, those are all good risk mitigation strategies, and they may go a long way in mitigating liability as well in the event that anything should happen in your workplace. So that is it for me in terms of the substantive part of my presentation, and then I guess we'll turn it over to further questions now.
Thanks, Christy. I'll just get you to leave your mic on, or have Jill leave your mic on. I just want to address some of the questions that went through the chat, and they're directed at you, Christy, from Peter. Just let me get back up to the top here. I just want to make sure I've got them. So Peter's first question off of the chat, and I'm just going to read them out for the benefit of the group. Will a new employee be eligible for subsidy? Was his first question.
Yep. Okay, and I see Peter's second question, or someone's second question too, is about eligibility for the self-employed. So those kind of, I'll answer those as one. So I'm assuming that means eligible for the CEWS, the wage subsidy, and the answer is yes. So new employees are eligible to be covered by the CEWS. For the self-employed, so the CRA has developed rules around anyone who's not operating at arm's length from the business. So if you're the owner operator, owner manager, that sort of thing, you're not at arm's length. There are some special rules about how that operates. You have to have been employed by your own business before March 15th. So that's one of the criteria. And then there's a slightly different way that you go about the calculation. That information is available through the CRA website. You can go, there are links that say employer eligibility and then employee eligibility. And that's a great place to find some clarity on that. But the answer to both questions is yes, just with the caveat that your qualifying criteria look a bit different if you're self-employed.
Okay, and then I noticed there's, Peter again said, my business has income, but I am paid from profit. Am I eligible for CERB?
That's a good question. My business has income. I think that would be very context specific. So I need to know a little bit more about how you've structured it and how you're drawing salary from the business in terms of whether you're going to max out that $1,000 threshold. If you are,
sorry, Christy, to cut off. It's really a question of how he's drawing the income, right? Like if it's a.
That's right. Yeah. Yeah, and that'll depend on how you've structured it, what your relationship sort of is to your business on paper. So if you have questions about that, generally we're saying the best place to seek advice on CERB eligibility should be your financial professionals. They have the best handle not only on all of the requirements, but also on the particulars of your business and how money moves through your business. So if you have a regular financial advisor or an accountant, that's probably a good question to direct.
Yeah, and that's where I've been directing my clients on those types of questions, because a lot of them, if you're taking it as a dividend per se versus a salary versus, so there's a series of structural questions you have to put to your accountant to know that. Right. Sliding down.
Peter is there, so I don't know if that answers it for you, Peter.
Yes, I was thinking I would ask my accountant about this one. It's a little tricky.
Yeah, and I mean, they're complex questions, Peter, just because it depends on how you're taking your income. So I mean, I've had, you're taking as a dividend payment or whatnot. There's a question as to whether you're qualified versus whether you're taking a salary and how and when and the frequency with which you're doing it. So your accountant's probably better situated depending on the structure of your business.
We normally calculate something at the end of the year and work out a draw of some kind at that point, but whether that's considered income, I'm not sure.
Okay.
Okay.
Yeah,
Thank you.
your accountant's probably best situated to address that.
So I don't know, do you want me to unmute Greg? He has a question here.
Yeah, go ahead. Sure. I can either read it out or Greg
Yeah,
can.
or we can just read it out if they've put it in the chat, either way.
Okay.
Well,
I'll unmute him in case he has a further question, but go ahead, read it out.
Sure. So so from Greg's question was, can an employer proceed with a termination without cause that was intended prior to COVID-19 after they were laid off and then recalled? If so, is there a period of time they would need to wait?
So this is one of those really annoying lawyerly answers that is a very contextual and fact specific question. So you'd need to know more about that. Anytime an employee has been off on a protected leave or temporary layoff and there's a recall, there is sort of optically speaking often a desire on the part of the employer to reemploy that individual for some time, but it really depends on what the reason behind the termination was. Now, you've indicated that it's without cause, but I hesitate to say go ahead or not. You're dead in the water and you have to wait 3 to 6 months or something like that without knowing more of the particulars around that situation. There's no sort of hard and fast rule that a valid without cause termination could not proceed, but there's probably a whole host of other information that I'd want to know before I comment too much further on that.
I see Greg's mic's open. Is that, I don't know if he's.
Yeah, so yeah, just if you had somebody that was employed and the intent was to terminate without cause with really no penalty to them, yeah, is it a 3-month window? Is it a 6-month? I mean, obviously it could trigger human rights. I don't know.
Yeah, so there's no magic threshold. Like there's nowhere in the case law where anyone has come down and said you must reemploy someone after a layoff or a protected leave or whatever for X amount of time. But as I said, optically speaking, the onus will often shift to an employer to demonstrate that they didn't terminate anybody. And this is a bit different for a layoff as opposed to a protected leave, but for the employer to demonstrate that they didn't terminate them for any reason whatsoever connected to them having taken leave. So you need to know a little bit about the employee you're dealing with, the business reasons, and what can be proven to substantiate the business reasons for the layoff before you can really talk about the liability that exists. Yeah, so I realize that's not a tremendously helpful answer, but I can tell you there's no kind of magic number or minimum period for reemployment. It's sort of context specific.
All right. Thanks for the question, Greg. Hope that was somewhat helpful.
Thank you.
Next, and Jill, Liz posed a question. I'll read it out for the group. And then if she has some follow-up, she can ask. But her question is, when refusing to be recalled, can an employee state daycare as a valid reason as daycares are currently closed? So I think that means if somebody's refusing to be recalled to work as an employee and their reason for refusing is that the daycares are still closed and I need daycare, is that a valid reason?
Yes. Yeah, so broadly speaking, yes, that is a valid reason because childcare obligations are one of the sort of subgrounds within that infectious disease emergency leave that I referenced earlier. And that particular leave remains available for the course of the declared emergency. So at least until, if the emergency order mandates the closure of daycares, as long as it remains in place as part of this broader declaration, which at the present time is until June 2nd, then yes, that's a protected leave, and it's an unpaid leave, so they're not entitled to sort of pay or necessarily benefits during that time, but they are entitled to a job protected leave. There might be a slight caveat for that if your business is a frontline essential business. Those are fairly limited, but there are some daycares offering spots for the children of particular frontline workers. In that case, you could perhaps be in a position to ask for evidence that the daycare is actually unavailable that may otherwise be, but I suspect that probably applies to a very narrow window of employers.
Yeah, we're not listed as essential at all.
Okay.
So is it, if we offer flexible working hours where she can work around her partner's schedule and just work a specific amount of hours for us, does that daycare provision still apply?
Yeah, so that is certainly, and we've seen this with our own clients. People are getting creative with their employees and saying, if you're just doing administrative work, for instance, you can do it in the evening when your husband's shift ends or however that works. You can't force her to do that. So how the protected leaves under the Employment Standards Act work is basically the employee declares that they're taking them, and then they have a right to do so as long as they continue to check the boxes of the eligibility requirements. And in your employee's case, if her daycare is closed under that emergency order, she checks the box for the duration of this declared emergency. So there's nothing wrong with engaging with the employee and seeing if she'd be open to accepting alternate hours if that's an arrangement that works for you, but you can't make that a requirement that she does so.
Okay. My one last question that pertains to that. What happens to her 13-week deadline then if the daycares continue to be closed? So she was officially laid off March 12th. So I'm just keeping an eye on the dates, but what happens if it goes beyond that?
Okay, so I'm a little bit confused then. So is she on layoff, or has she asserted the protected leave? Because if she's on layoff, but you suspect at the expiry of the 13 weeks, she's going to then take protected leave, that potentially is open for her to do. So it could be the day of expiry. You say, we're at 13 weeks, you're now recalled. Technically, she's no longer on layoff and she's employed by you again, but she can then assert entitlement to the protected leave. So that is fluid. There's nothing that stops her from taking the leave just because she's been on a layoff, or vice versa, potentially.
Okay, that answers my questions. Thank you very much.
Thank you. Another one that's popped up is what if they are refusing to return? So what if an employee is refusing to return to work during office hours out of a general fear of COVID, even though safety standards are in place at the office?
So then you're probably in a situation where that, because it has that health and safety hook, is falling within that work refusal under the Occupational Health and Safety Act. So if the employee has made it clear to you that the reason they're not coming in is because they have doubts about, the office being a safe workplace, then the Act sort of sets out how you address that. You need to clarify what the employee's specific concerns are. So if they think it's around like public access, sanitation, whatever it is, conduct your employer side investigation. Let the employee know how you respond and how you're going to, deal with their concerns or remedy them. If they continue to refuse, that's where it becomes the time that you have to engage the ministry inspector. The inspector will come in and make a finding about whether the work refusal is valid or not. If it's not valid, basically it's employee get back to work, or, if you're not back by X date, it will be a deemed resignation, subject, any special health considerations that we talked about. So you'd want to get some clarity on whether they're asserting anything like that. But otherwise, sort of a vague or general fear is not sufficient, but you would be wise to treat it as a formal work refusal and kind of deal with it through that mechanism.
And your mic's on, Sharon, if you have, does that address your concern? I don't know, she's got her mic's open, but so there's no response there. So I think that addresses it. So, so that we've addressed the questions that have been put to us. Jill, I'll hand it back over to you. I don't how you want to proceed. We're happy to answer any other questions, but if there's none others forthcoming, I just wanted to thank everybody for allowing us to speak to you today, and Jill for facilitating this on behalf of the chamber. We really appreciate the efforts to coordinate this.
Yeah, no, thank you very much. You're right. I don't see any more coming through, and I do want to thank those who did offer some questions. That's great. If there aren't, I think we have everybody's email addresses kind of sitting in that chat. I will grab the transcript from that. We've also recorded this call, so we'll make that available to people who are interested. Some good questions, I think. Thank you very much for your answers. We all know that it's a very different time and we can't predict exactly how things are going to work out, but certainly your assistance as we navigate through these uncharted waters is much appreciated.
Yeah. Thanks, everybody.
Thank you.
Thank you.